Thank you, Mr. Chair, and thank you for hearing from me. I'm one of the lucky 0.1% who get to make an oral submission. I'll be as brief as possible, for I think questions are the best part of this. So I really just want to make one point and perhaps pose a challenge to members of the committee. The one point I want to make is I do think it would be a very good thing for there to be a parliamentary or legislative definition of the principles of the treaty. The reason for that is twofold. The first is certainty. I think a lot of the challenges we've had in the last 5-10 years are people are uncertain. They are anxious over how interpretations of the treaty impact them. We've seen recently the last government had a select committee, independent group recommend all councils be co-governed 50-50, Māori, non-Māori, as part of the principles of the treaty. Now, that's a big issue. Not everyone agrees with that. People are worried about what this may mean to them. So I think having Parliament come in and say, we're defining or clarifying the principles is a good thing. Now, you can say, let's leave it up to the courts. But ultimately, these are political issues. They're not just judicial issues. You will not get the public acceptability, the legitimacy, if you just say, this is all going to be decided by the courts. And what it will lead to is more like the United States, where if you're going to say the courts are the only people who decide this, then judicial appointments will become political. There will be a litmus test. How are you going to rule on these issues? So I would love to see Parliament actually step up and do its job as legislators and say, these are what we think are the principles of the treaty, because you are the Parliament that's put them in 20 or 30 different acts of Parliament. Now, personally, I quite like the principles in this draft bill. I think the second one has come a long way from the draft act policy in trying to recognise rights of hapu and iwi, but I also recognise this is controversy. Not everyone likes that. I would happily go with principles defined by Parliament that I only partially agree with, 55, 60%, then there be no principles at all defined in legislation, because I think getting them into law would be a good thing. The challenge I would like to pose to, I guess, Parliament members of Select Committee is, if parties don't like the principles in these bills, I would love to see each party put forward, these are the principles we would like to define in legislation. That would allow New Zealand to understand what the different perspectives are, see where there is common ground. There might be very close similarities between Labour, Greens, Te Pāhi Māori. There might be closeness between National and that. We might end up that we've got two different visions of the principles, which would then allow us to have a more defined conversation. What I don't want is just a status quo of, we think everything's happy, we don't think there's anxiety over these issues, and we're just going to leave it to the court. So that's effectively my submission. Very keen to have questions.
Thank you, David. We've got 4 questions lined up. First from Duncan Webb and then Timothy Paul.
Don't get too carried away being in the top 0.1%, David. But look, I do have a question, and it's around focusing these principles or freezing them in a piece of legislation, because in your written submission, you identify that over time, the way in which the treaty has been viewed has changed with perceptions of it and social circumstances. You refer to Farrar and Nata. Isn't there a risk if whatever principles we choose, that in fact we do our future selves a disservice? Because in fact, as some would say, it's a living document that its understanding changes to meet society's needs as it progresses.
Very good question. Thank you, Dr. Webb. The nice thing about principles and legislations, and the Privacy Act's a good example, is they can actually adapt over time. Our understanding of principles can change. So it's not calling for a statutory text of this is exactly what the treaty means, effectively putting the treaty in legislation. But I think defining principles will still give you flexibility. To a degree, I really think, though, what this is about is almost setting an upper floor or limit. People are concerned about, does the treaty mean that equality of suffrage is something that is at conflict with the treaty? If so, how is this resolved? That's not a question that's going to go away. And that's where I think Parliament can provide some certainty by saying, this is how we interpret the principles so that people can feel reassured there. I don't think it would be a straitjacket. I think if you look at the 3 principles in this bill, there's still lots of room for interpretation.
David, we've got a question from Timothy Paul, then Dr. Ferris.
Kia ora, David. Thanks for the 1-page submission. Really appreciate when it's nice and succinct. Makes it easier to digest. I appreciate the points you make about certainty, but do you think that this bill actually is far more uncertain than the status quo? Because at the moment we've got settlements in writing and we've got jurisprudence in writing, and both parliamentarians and lawyers and whoever else can rely on that, whereas this bill is an effective reset button. And so that throws all of that all up in the air and creates far more uncertainty than we have right now. So just trying to understand your logic there.
Thank you for that question. I think the settlement should be unaffected because, as I understand Principle 2, it specifically refers to that settlements can give different rights. In the short term, you are right, there would be more uncertainty. When you ever change, like when the RMA changes, as much as people that like the RMA, you'll have a temporary period of uncertainty. In the medium to long term, which is what I think is more important, I think you would end up with greater certainty. So short term, yes, there would be, you wouldn't be able to rely on the jurisprudence, but I think in the medium to longer term, it would be more certain.
For who?
Well, for government, because I think you have a lot of government agencies trying to interpret what these treaty principles and their acts mean. I think for Crown law, and I also think for the courts themselves. It's quite common for Parliament to say, look, we don't think the courts have quite got this right, so we're going to clarify things further. So I think the certainty can apply to all of those, but it will take time.
Thanks, David. We'll go Takata and then final one from Todd.
Kia ora hoa. I sort of hear what you're saying, but you see, the trouble I have with your view in the submission is that it's sort of built on the premise, or it assumes that MPs understand Te Tiriti o Waitangi, or that they understand the history. And I can guarantee you that's not the case. There is also no prerequisite for an MP to have such skill sets or knowledge sets. So you will always be on the back foot if that's the approach you take. If we take the status quo idea, well, the status quo is just a maintenance of an ignorant state. So our real problem to move forward in a manner that you are describing, David, is how do we educate our people? And what level of education do we expect of our decision makers, our lawmakers? So what do you think about that? What sort of expectation should we have for MPs and figures of power when it comes to this being capable of deliberating this type of thing?
I'm a bit optimistic here, you might say unrealistic, but I think there is ignorance, absolutely. You can spend months reading the histories of the period and still not be sure what was intended back in the 1840s. But if we actually had the 6 parliamentary parties come out with, here's our interpretation of the principles, that would actually start the knowledge with both other MPs, but also the wider public at understanding there are differences of views, and then being able to have those conversations about, well, what does the historical record say? How does this reflect our value today?
That's the work the tribunal's done, right? For 50 years.
Sorry, folks, that's the remaining time in the session. I'm going to have to interrupt there. Thank you, David.
Well, there we go.
Confusing. I don't think David understands how much work the tribunal's already done or what the tribunal does. Okay, look, we all agree that we need a parliamentary definition of the principles. What we disagree on is the fact that iwi and hapu were excluded from the process.
Yes.
You can't define your obligations to your partner without involving your partner.
Exactly. And I think that's exactly why Takuta was pulling him up on it as well.
Yeah, it's undemocratic to do it that way.
Exactly. It's just ridiculous.
Mm-hmm. And, and Takuta Ferris brings up a very good point.
Exactly.
How do we educate the MPs? They've got different political biases. How do we, shouldn't we have an unpolitical position in how the treaty ought to be interpreted, aka what the tribunal's already done? Yes. Just because you disagree with their findings, it doesn't make them woke. These are people that have spent years and years studying the subject.
Exactly. Just, like the whole argument last year with school lunches. Mm-hmm. Just because you don't eat quinoa doesn't make it woke.
No. It just doesn't make any sense. It's like saying, oh, that scientist is woke because I disagree with their finding. It's like,
exactly.
No, it's not.
It's ridiculous.
Yeah. I like what Duncan Webb also said, that the treaty is a living document. Yes, that's why the 3 Ps are really good.
Yes.
That's why I really like the 3 Ps. And I think personally that should be the parliamentary definition. I think what the courts have, what the tribunal has established that different departments ought to follow? Yes, the 3 Ps. And as a previous person just said, I think it was that ex-national MP, the guy with the Bar Association, but he said that the 3 Ps are already being interpreted conservatively. That doesn't sound woke to me. Woke is progressive.
Exactly. It's all woke is saying that your eyes have been opened and you are seeing things differently.
Mm-hmm.
Preferably in a better light than you had previously.
Yeah, I just don't think David. I mean, I'm not familiar with David's previous work. People in the chat were saying, "Oh, David." I'm not familiar with his work. His work. All I know is that the opinion that he has expressed, just demonstrates he hasn't done much reading into what the tribunal does and their reports. He's the owner of Courier Polling. Really?
Yeah.
The owner? Okay, I expected a bit. Okay.
Yeah.
Okay, I was expecting something a bit more than what he presented.
Right. If that's the case.
Okay, I'm shocked. I'm actually quite surprised. David, come on.
Yeah. And kia ora Kiwi Skirt, it's good to have you back with us.
Anyway, that's my monologue.
Yeah. Say.
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.